Members, we have formed a quorum. I now call the meeting to order. I'd like to welcome from the Transport and Housing Bureau, Mr. Eugene Fong, Deputy Secretary, and also Mrs. Hattie Chi, Principal Assistant Secretary for Transport and Housing, Ms. Sharon Cole, Senior AO, Special Duties, Mr. Lawrence Pang, Senior Assistant Law Draftsman from the Department of Justice, Mrs. Maria Lam, Assistant Director from the Lands Department. And also from the Lands Department, we have Mr. Armstrong G, Chief Land Conveyancing Officer. Last time, members asked the administration to provide information, the second draft on the guidelines to be provided under the Residential Properties First-Hand Sales Ordinance, as well as some major issues of concern. So this has been provided by the administration. It's CB 1686-1213-01. Over to Mr. Fong for an introduction, please. Thank you, Chairman. In response to members' request, we have submitted a paper to this subcommittee. In the future, the authority, First-Hand Residential Properties Authority, would issue the three types of documents. First, guidelines issued under Section 88 of the Ordinance. Second, practice notes. And third, frequently asked questions and answers, FAQs. We have annexed the three documents in our paper. Guidelines, practice notes, and FAQs will cover some aspects in relation to sale of first-hand residential properties, i.e. sales brochure, price list, sales arrangements, and other information, register of transactions, submission of documents to the authority, and submission of information through the sales of first-hand residential properties electronic platform. Guidelines will be issued under Section 88. They would mainly provide guidelines on how provisions of the ordinance can be complied with. For example, how are we going to calculate the 7 days? Because according to the ordinance, the hard copies of the sale brochure must be made available at least 7 days before a date of sale. And then there's another requirement for the price list, which has to be provided at least 3 days before the day of sale. But guidelines are not statutory legislation under Section 88, bracket 3. As for practice notes, they are good practices or best practices when it comes to information provided by vendors who would like to see standardized practice. For example, in submitting documents to authority, how can a vendor do this? Non-compliance with the best practice per se will not be regarded as a contravention of the ordinance or commission of an offense under the ordinance. As for FAQs, they aim to facilitate the trade to understand how the authority look at specific provisions of the ordinance. We are now looking at the second draft, and actually all the stakeholders have also been given the draft. In the coming 1 or 2 weeks, we will have further meetings with stakeholders. The major concern of stakeholders can be summarized into a few categories. First, they would like to know clearly the nature and status of the guidelines, practice notes, and FAQs. We have made it very clear that non-compliance with the practice notes is not a contravention of the ordinance, it's certainly not a criminal offense, and we have also set up relevant information in the FAQs. Second, they have requested that in the guidelines, practice notes, and FAQs, we should provide more details. In the past few months, during our discussion with the stakeholders, we have supplement and increase the number of information provided in the 3 sets of documents, including in respect of areas whereby information was considered not sufficient. The Law Society and the reader has expressed the view that whether it would be rather rushed to implement the ordinance or to commence the ordinance at the end of April 2013. Well, we are of the view that the relevant parties have been given sufficient time to get prepared. As members are aware, the ordinance was passed in June, and all along we said the ordinance would commence within 12 months. And also in paragraph 14, we set out some points which we made last time, and that is we are well prepared in relation to various aspects. And next issue is transitional arrangements. Reader consider that for sales, brochure, price list, and self-arrangement of first-hand property which have already been made available before the 29th of April should not be subject to a requirement of updating if they continue the sales arrangement after 29th of April 2013, and they would only be required to comply with the new provisions if they continue to sell for 12 months or beyond 29th of April 2013. Well, but what we mean is that the relevant provisions would commence to take effect after the 29th of April 2013, and any sales arrangement that takes place or continues beyond 29th of April will be subject to the requirements in relation to sale, brochure, price list, and so on. In paragraph 17, we set out the final transitional arrangements, and that is the Lands Department will in due course issue a circular memorandum so the vendors can apply to the Lands Department for sales brochure and price lists which were printed before the 29th of April, so that they don't have to comply with the requirements that would be applicable after 29th of April. That's a transitional arrangement. To ensure that the sales can proceed smoothly before and after 29th of April, we are going to accept applications or the submission of applications for the new formats of sales list and sale brochure in advance, as long as they comply with the 7 days requirement and 3 days requirement, so that they can continue the sales arrangement that started before the 29th of April and continue after that. I think the trade, the industry is aware of what you have told us. All the arrangements, including the transitional arrangements, were already set out in the first draft. In the second draft, there has not been a lot of major changes. So the Law Society and reader are both made aware of the arrangements. And in early April, we are going to organize a few workshops. Developers and relevant stakeholders will be invited to attend, and we would brief them again concerning the 3 sets of documents. Mr. Tam Chung, they have guidelines and practice notes. What is the legal status of these 2? Do they have to comply with the requirements in those documents? Mr. Feng, if you want to say that an offense has been committed, then you have to look at whether the provisions in the ordinance have been breached. Because although the guidelines are issued under 88 bracket 3 says non-compliance is not a offense, and also under 88 bracket 5 non-compliance with best practice or guidelines are not per se a breach of the ordinance. But if there's an issue in a court, and something is at issue related to the guidelines, then the guidelines can be presented and taken on board for consideration. And also, the guidelines and practice notes cannot be used in any proceeding to establish or negate the matter at issue. So it will not incur any liability, criminal or civil liability, and non-compliance with the best practices will not be regarded as of a breach or an offense. As for the FAQs, the aim is to facilitate the trade to understand how the authority look at specific issues of in the ordinance. If the trade has doubt, well, they should seek their own legal advice.
Chairman, well, for other pieces of legislation, guidelines may not be in the form of ordinance per se, but it will stipulate that you must comply with the guidelines, otherwise you will face prosecution. Will there be a similar requirement? Well, for the guidelines, the nature is for explaining how the provision operates. For example, it sets out the template of the price list and the format of the submission form. So in relation to the guidelines, I believe that the industry will, by and large, comply with them. In the case of non-compliance, we will, through READA, get an understanding with the industry and see whether there are any issues in relation to implementation. Now, whether it's practice notes or guidelines, depending on the actual operation, we can make amendments in the future. Mr. Abraham Shang. Well, this is just like a book. Selling flats is even more difficult than selling white powder. Well, guidelines, well, it's very clear. If you sell white powder, you will be arrested, whereas for selling flats, well, it's not clear what's said in the guidelines. Well, just now the administration says that if you are not clear, you should seek your own legal advice. But if things are not clear, why the need to draft the guidelines? Because the purpose is to serve the industry and the public. You should make things black and white. Well, you should not wait till people get arrested and prosecuted before you come out and clarify. And this is not the attitude the administration should adopt. They refuse to make things clear until something happens. And we have the whole team here. We have the officials here. How come they cannot make everything ready so as to serve the public and the sector? Well, they say we should ask our own legal advice. What happens if different lawyers give legal advice? The guidelines should be very clear. Mr. Fong, Chairman, perhaps let me clarify. For FAQs and practice notes and guidelines, everything is very clear. The guidelines are very clear. I said just now that when it comes to FAQs, we recommend vendors not to take it as a piece of legal advice. Should there be any questions, they should consult their own lawyers, because be it practice notes, guidelines, or FAQs, they provide answers in terms of some principles. But when it comes to actual individual cases, the background may be different. And the background of individual cases may have some bearing on the decisions to be made. And in fact, for the guidelines, practice notes, and FAQs, they've made clear a lot of questions. We have discussed these matters with the Law Society and reader and other stakeholders. We welcome comments on how these can be improved. They have indeed provided many comments on the first draft, and we have tried to adopt as many comments as possible in the second draft. Chairman, well, they have not tried to reflect all the comments as to the best they can. You can see that the second draft is not very different from the first draft, so they seem to be listening, but in fact they have adopted a few comments. Chairman, the problem is when you enact legislation, you should make it clear. You should not entrap people. So you should tell people what can be done, what cannot be done. Because if you dodge questions every time and wait until somebody gets caught, well, this is not the spirit of legislation. The administration should not be aiming at catching people. So about the sector's view on the guidelines, I think that the guidelines can still be amended in subject to any views. Now, Mr. James Toh, now about the development project, let me cite this as an example. The balcony or the bay window is sunken so that it's right facing the carriageway. It's in Maongshan, I suppose, so, or near the Science Park. So this is what I call a special feature, let's say. So how can this be reflected in any of these documents? I don't know how to put it. I'll just put it a special feature. Thank you. Now, just about the development project you mentioned, in fact, the level of the bay window is lower than as stipulated. Well, actually, in Schedule 2, and in fact, it's A2530, page A2530, it says that the sales brochure must, in relation to each block of the development, set out a plan. There should be a cross-section plan in relation to the building and the street across, so that so that it shows the difference between the height of the floor and the level of the road in the principal datum, so that you can see whether the lowest floor is actually above the ground level or below the ground level. Now, let me ask, let me just follow the logic. So you mean that the lowest floor of the building and the adjacent street, in relation to these two, or in relation to the level of these two things, a cross-section view should be provided. But let's say if there is a building and then there is a street on the inner side, and then it's at the same level as the lowest floor, but people may think that the level is actually lower. Well, and apart from that path, there is also the main street that is as high as the fourth floor of the building. So which should count because it says adjacent street. Is it okay just to show the internal street? So there is a cross-section diagram, and in fact, in Annex C, we have this diagram explaining different situations. I know, but my question is in relation to my case. Am I right in saying that? Because you only require the adjacent street to be shown. Say it's a single carriageway. Sometimes there is a road, a circular single carriageway road surrounding the building. Even if there is a slope and another street at the level of the 4th floor, then this requirement can still be met as long as the circular road is shown. Let's say adjacent to it there is a slope. Is it necessary to show the height of the slope? No. So, for example, I buy the floor on the ground floor. Now I understand how the level of the floor, but the second floor, I don't know the height of the slope. Chairman, now according to the ordinance, there is no requirement on the level of the slope to be shown, but there is another provision, and that is to say, if some information is known to the vendor but not to the buyer, and that the information will affect the enjoyment of the prospective buyer, then the information should also be set out in the sales brochure. Yes, that's exactly what I'm thinking of, because this is the guidelines. Now, you talked about provision of the ordinance, and that's legislation. For guidelines, they provide more details. And I'd like you to give this a thought, because over the past decade or two, I have seen so many examples. The developers are very creative. I cannot say that they are deliberately misleading the buyer of the second floor flat, but then the buyer may feel aggrieved. So you were talking about the general provision. And we don't want to see victims. Now, about the example I quoted, please give it a thought in relation to the guidelines. I know that there is such a provision, but I hope that you can look at the details. Now, yes, a buyer may think that, yes, this is what's happening to me. But then you may have to go through an argument on the guidelines. Yes, I will consider the members' view and see how we can deepen this aspect. Chairman, of course, I know that this is not non-residential development, this is residential development. But let's see, we have, well, for example, let's say we have a residential commercial development, which is rare for new development projects. But anyway, do we have anything in the guidelines that deal with such developments? Chairman, I want to clarify, that is to say, you know that there are residential commercial development projects. Of course, I understand nowadays we rarely see these projects. But let's imagine we have a residential commercial development. Will there be any chance of abuse, or how are you going to address this in your guidelines? Chairman. Now, the guidelines provide supervision on sale of first-hand residential flats, and in the future, as the ordinance targets residential properties, we can only enforce the ordinance on the residential properties. But is it only confined to residential properties only, or will residential commercial properties be excluded or included? In fact, in the primary legislation in Section 6, it stipulates that residential properties means properties mainly or primarily or exclusively used for residential purposes. And it stipulates that it excludes other premises regulated by the Guest House Ordinance. Well, but let me give you an example. Well, let's say if some flats got the occupation permit and commercial uses are also allowed, will they be subject to this ordinance? Well, if it's a residential commercial mix, then it depends on whether it's mainly for residential purpose.
主要嘅 feature 裏邊。
Do you have anything special to deal with such a feature of mixed use? Have you considered this, for example, this question? You have to tell the buyer that this can be for commercial use as well. Or in the DMC, deed of mutual covenants, there will be special provisions governing this aspect. You have to tell the buyer. All the first-hand sale of residential properties will have to comply with requirements on sales brochures. For example, the major provisions in the land lease and also the major clauses in the DMC must be set out. If there's something that may affect the purchaser's enjoyment of the property concerned, then the information must be set out in the sales brochure. Well, I believe this requirement can address the members' concern, and the vendor it will be required to set out the information in the sales brochure. Well, that's too general to me. If it's residential commercial development, let's say the residential properties are more expensive because of the potential to use the properties for commercial use, the value may be affected, the price may be affected. And if that's the case, for example, the purchaser may have to live in a flat, but the next flat will be for commercial use. Would you be setting out the information for the information of the purchaser? Well, I think this is covered under the relevant information requirement. That's a very wide provision. Anything that the vendor knows and the purchaser is not supposed to know, and such information may affect the purchaser's future enjoyment of the property, whatever the nature that may be, that would be subject to the information provision requirement. Otherwise, it's a breach of the ordinance. In the initial draft, there was no such a requirement, and now the monitoring mechanism is such that in the sales brochure can only contain information that we require. And then there were members or stakeholders asking whether we should allow the information to be provided to purchaser for the sake of the consumer protection, although such information is not strictly required under the ordinance. There should be a heading under relevant information, under which all information that might affect the purchaser's enjoyment of the flat should be set out. Chairman, perhaps we should invite the administration to consider the scenario that I have suggested. Perhaps we can give some examples concerning what should be provided under relevant information. I don't know whether the other side would argue about the coverage of the general provision. Of course, you can check the OP, you can check the land lease. So you will say that such information is known to the parties, and they would not be covered under the relevant information. Well, actually, some stakeholders raised exactly the same point. There are three elements here. The vendor knows the information, the public don't. And then the third element is that such information may have a bearing and affect the future enjoyment of the purchaser of the property. We have sought advice from the DOJ, and the Law Society and REDA have both commented that information that can be accessed in the land registry should not be regarded as information not known to the purchaser. So based on the advice from these three parties, we have made it very clear in the guidelines that information that can be accessed through the land registry will not be regarded as information not known by the public. Can you repeat the last sentence? And that if a piece of information is registered with the land registry, then it should not be contained in the relevant information provision here. So they would argue that the commercial use is the information that you should have known. Well, call me mean if you like, but this is the way the mentality works. Let's say if it is for pure residential use, the value is higher than mixed use. So the marketing would stress that it's for residential, without specific reference to the potential use for commercial. The OP and the land lease have all been registered. So there's no need for the vendor to specify such information in the sales brochure. Well, in the relevant information, well, that's the other parts in the sales brochure other than relevant information. There must be a gist of the land lease provisions and also relevant clauses in the DMC. So if we discover in the future a case like what you have described, we'll ask the vendor for an information. Why such information is not set out in the gist information of the land lease or the OP. And of course, if appropriate, we can establish a case of breach, and we can press prosecution. We hope information that the public are interested to know would be in the sales brochure. I think you should set this in the guideline, that you should tell the people that is for both residential and commercial use, in my example. Perhaps we can give some coverage to this as an example in the guidelines. All right? Anything else from other representatives of the administration? If not, then I think we have completed this item today. And let me remind members, through a resolution, the scrutiny period has been extended to the 27th of March. And we are going to make an oral report to the House Committee on the 15th of March. I will do that. And the deadline for giving notice to amend the subsidiary legislation will require a 5-day notice, and that is to say the deadline is the 20th of March 2013. So members, please be informed of this arrangement. If you want to move amendments, please do this before the 20th of March. If members have nothing to raise, I'll adjourn the meeting. Okay, so that's it for this